is yours. Go! Yeah, I was building on the lecture. Verses coming daily under pressure. Working on the plot and the scheme. The true style trademark is at the edge of your dreams. I'm talking one shot for the kill. The breeze cut, freeze up, straight dropping the chills. I'm talking taking over pieces and shares. A bomb break sky high. Check the movement is here. Yeah. It's one heart, one shot. Now the future is yours. Go. Turning dreams into reality. In the lab with the formula and chemistry. Your memories spark and motivate and make the industry shake. We put the bars in the brakes. I'm talking one chance at best, yes. Painting pictures for the culture, keep the brushes fresh. Flip the cover, work the drummer, passion never rests. Freedom is our teacher under pressure, now we blessed. See, I was so good for the go. There's one art, one shot, now the future is yours. Go! Yeah. It's one art, one shot, now the future is yours. Go!
You know, the insurance carriers would have it. Those lobbyists would, you know, they wouldn't know that contractors are anything but, you know, greedy, you know, stealing, lying, cheating people that, you know, sling shingles out the back of their truck and, you know, buy extra bundles on the side. It just not, it doesn't, the representation is not there for contractors or policyholders. Which doesn't make sense, but when you understand how much money insurance companies are pouring into not only lobbying, but advertising. I mean, State Farm, Liberty Mutual, Nationwide, and Allstate, those 4 companies are in the top 10 of television spending and advertising every week.
To make policyholders feel like they're
your good neighbor.
Yeah.
Yes, you're in good hands.
Yep.
Welcome to the American Contractor Show, the show that's all about American contractors living the American dream. I'm your host, John Dye. Each episode will introduce you to contractors just like you who have beaten the odds and leveled up their game to become the dominant force in their markets. Together, we'll explore the tools and tactics that unlock the secrets to their success. Join me as we begin the journey that leads to the realization of your American dream.
So we're here with London Crounse. He's an attorney here for Daly Black. And you guys work really closely with Apex and with Mike and his whole team on several different projects. And I think that's a thing that most contractors look for when they think attorney. They're going to basically at that point, it's because they've exhausted all their other options. And a lot of times, let's just be honest, like the claim's in disarray or the whole process has been messed up and they're trying to salvage it. And so they call in a hero like London to come in and save the day. But let's talk a little bit about how your guys' relationship actually works and why it actually is something that makes sense for both of you.
Sure.
So,
by the way, I'm no hero. I'm Clark Kent on my best day, but I'll let you take the question, Mike.
So we use London for reasons, you know, depending on how the claim is going. Basically, you know, if we're getting to a point where we can't, you know, the insurance carrier is saying, they don't naturally really have to talk to us in the first place.
Right, you're just a contractor.
Right, a lot of insurance carriers, especially down in Texas, they'll tell you, or Florida, I don't have to talk to you, you're not an attorney, you're not a public adjuster, kick rocks. So, I mean, in the real world, they could say that up front if they wanted to. I mean, a lot of these claims that we've taken, that London has taken for us and helped us close these claims out really quick, he gets a quicker response because he is an attorney. He does have he is the law. So, you know, he's representing the law. And so when he comes in and does these claims for us, I mean, you know, instead of us waiting 6 months or a year and a half with a public adjuster, you know, London comes in 2 months or 30 days or 3 weeks. I mean, he's had claims where he's fired a couple of them off and they just settled them within a couple of weeks, and we're doing the roofs. So from that experience of being with London and Daly Black and having them as a resource for us to actually use for all of our sales reps and us in the office, it's so easy because we document every single thing that we do. We get all of our paperwork together for him. We make sure we've got all of our photos, all of our documentation together. And then when we turn it over to him, he has a loaded gun where he can go to and say, you know what, you guys are under bad faith, you're under time, you're delayed, whatever it is that he needs to go to the insurance carrier and say, we have proof of it. And so I would say to contractors out there, That's the most important part of this process. If you're doing these bigger projects, $1 million, $4 million, $12, $15 million projects, you need to make sure that you're not only being represented by somebody like London, or London, really, to do these claims. Because I mean, when the insurance carrier is going, oh my God, I'm going to have to pay $12 million for this roof, or $15 million. Yeah, you're going to have to pay it. And then they're telling the contractor, well, we're not going to pay it because of blah, blah, blah. And they keep dragging it out, and you get London involved, all that stuff just goes away. And they start tightening up real quick. Oh, wait a minute, let's go ahead and settle this claim, because they know that it's going to be treble damages for time, treble damages for delay, treble damages for bad faith. And once you start taking a bigger project to $1 million and up, you know, it doesn't matter what the actual number is, but let's just call it $1 million project, and you got them on bad faith, that's $3 million. Yeah. You got them on time, that's $3 more million. You got them on delay, that's $3 more million. They don't want to go down that road. So and naturally, they want to settle with London sooner rather than later, which helps us be able to get some of these bigger projects, you know, and going. And then we do the work already; it's already done. And now they're arguing with us on scope. They're arguing with us on, you know, how much did this job actually cost, and this and that. And it's like, well, here you go, London. You go ahead and take care of it, and you talk to them, because they're not going to talk to us at that point anyway.
Yeah, for sure.
So that's what happened on the last one, where the guy was just like, excuse me, I'm not going to pay you any more money. You agreed to my scope of work up front. I'm like, that was pre-construction. I said, all I was agreeing to you with is the code items that you
were
listed
guessing
initial.
just along with
Yeah, I mean, I can't see through the roof.
Yeah.
How many layers are underneath there? How many layers of felt? I mean, a lot of the roofs had 2 layers. A lot of the roofs had 2 or 3 layers of felt. Our labor went through the roof. He didn't want to pay for any of that.
At that point, you hit a brick wall. You're trying to figure out what to do.
Yep.
And then London steps in and tell us a little bit about what, you know, in that situation, how you're able to help Apex.
So he called me, actually, I think you were only intending on doing 2/3 of the buildings based off their original adjustment, right? Mm-hmm. And, you know, I said, we've been to this movie before. They're agreeing with you on scope. Why don't you just finish the job and let's go fight over the rest of it later, which is exactly what he did. And I think his client was probably happy about that, because the HOA board avoided an angry mob of homeowners in buildings 26 to 32 coming down there asking why 1 through 26 got fixed and they didn't. But no, that enabled him to do that. He had the confidence to do it because we've settled cases for him and delivered results before. And you know, I was confident based off of just looking at it and knowing, you know, typical price per squares, whether there was 2 layers or 3 layers. That's easy to prove once we get the roof off, and he can document it. I mean, he took over 4,000 photographs according to my instructions as he was doing that. So I've got more than enough documentation to prove what was done. After his estimation, we had him send an invoice for exactly to the penny what it cost. And I think that was actually less than his original estimate, appearing more reasonable. The carrier didn't pay but $1 more than I think their original estimate 9 months prior. Yeah. Didn't even pay for the $30,000 permit fees on a multi-million-dollar job. I mean, it just their bad faith meter just continued to go up as you know, the you know, he acted more reasonably on the claimant side. Claimant only concern was they don't want to have to owe anything if he's going to do the job, and that's essentially what we did. We gave that promise that they won't owe anything beyond what we're able to obtain from the carrier, whether it's pre-litigation or post-litigation.
Yeah.
So we're almost there.
How important was it, though, that he had all that documentation ready to go? Had he not had it, like what would that do for your process?
Well, they agreed on scope. Things like layers would be difficult to prove. They could argue spoliation of the evidence. You know, it just enables me to prove. You can tell me what happened, but it's still an adage of not what we know, what we can prove. So I need documents, I need emails, I need photographs. Not just photographs, I need to know who took them, where they took them, when they took them. And is that person available to come in and qualify those and lay the foundation so that I can get them admitted into evidence? Mm-hmm. That's what I have to do to get things admitted into evidence afterwards.
Faster, right?
But what he does, so if you think what I have to do to lay a foundation to get something admitted into evidence post-litigation,
oh yeah,
that's a lot. I have to prove where it came from, all that. Evidence is what the reasonableness of the carrier's conduct is determined by the information that was available to them at the time they made the coverage decision. Okay, I'm not around usually when they're making the coverage decision. He is. He's the one that's promulgating the information that makes it available to them, that determines the reasonableness of the carrier's conduct.
Right.
So if he's the one that's providing all this information, if he's providing them this, and they're returning back this, i.e. a reservation of rights letter citing a number of exclusions that may or may not apply, and failing to make a coverage decision, and he's asking for, please release all undisputed funds, and they're sending half of what he needs, what's their reasonable basis to dispute the other half? Unless they provided it, which he knows to ask for that, please release all undisputed funds, or otherwise provide your reasonable basis why you won't pay every line item of my estimate. That's how he's been taught to send over, either the policyholder sends it and he sends it. Once that's been provided to the carrier, that information is there, what reasonable basis do they have to deny it? They've got to make up one, and if they don't, they're in bad faith. So, I mean, we've been working, this is the third office you're in now? So, I mean, it's much nicer than the first office. But no, working with a buttoned-up contractor that, you know, has their shit together, that, you know, not only just Mike, but I mean, his sales guys. I mean, they have regular meetings, they keep everything in tune. When industry changes happen, when they start denying appraisals or, you know, a new policy exclusion comes up that we need to look out for, they know about it. I mean, they're asking the insureds, you know, and can I see a copy of your policy so we can see if Colorado mandatory endorsement APV 275 is in there, because it's been a problem for every other neighbor on the street. And so they're you know, wise on that, on those sort of trends in the industry, and therefore it makes them better at selling. They're able to provide that information. Information's power. And when, you know, they're saying that, and the last two guys that knocked on the door never asked that question, they now know that he knows something that I don't, and that's why I'm going to go with him, because he's probably going to help me get to the result faster than not. And that's what it's all about.
We have one in Louisiana right now that we're working on, and the guy's underinsured. So the insurance carrier, I got London on this one as well. The insurance carrier is saying that the building is underinsured. So they're saying that the building is worth $1.2 million, but the policy's only $700,000, and that if let's say a hurricane comes through, which it did actually to Laura and Delta, it hit the building and tore the roof off, tore all kinds of stuff up, tore walls up, blew the windows out. Gonna have to redeck the whole building, put a new roof on it, redo the awning, redo all the floors, everything, basically a full gut. They're saying that since this guy's underinsured on the building, that it's his responsibility for anything over that amount, which it's their job to insure the building for what the building is worth now. And so
that's because there's an 80% co-insurance clause on it. Yeah.
And yeah, maybe explain that a little bit.
Yeah, it's complicated. It's going to bore the crap out of everybody. But essentially, you know, what the contractor needs to do in that situation is provide an estimate that falls within that 80% range. If they do that, these are total losses, I would imagine.
That building is still standing. I mean, I think we can rebuild it, but...
So he can provide a repair estimate, and then he can provide a replacement estimate. I mean, the value of the replacement cost of the total building is that which a contractor would rebuild it for, and Mike can do that. So, I mean, that would be my recommendation there. And that sort of, it's not dispositive on the issue, right? But it gives me fruit for fodder to go argue that and to go, you know, make an argument that I'm actually, no, these buildings weren't underinsured. And, you know, if the replacement, you know, if one contractor is willing to replace it for this, then that's what it is. Or we can ask other contractors what they would replace it for. So, I mean, there's information there that's available to help me fight that, such that the insured is not responsible as they're trying to hold them to.
It's crazy, man. There's so much change going on, and it's wild, the stuff that we see as contractors that you guys are dealing with. Daly Black is dealing with a lot of stuff. You're dealing with a lot of stuff on a legislative level as well.
That's right.
A lot of attorneys, I think a lot of people don't realize what it is that you guys are really doing when it comes to the legislative stuff, but what is happening right now on that front that is hopefully helping to change some of the things that we struggle with as contractors?
Sure. So right now, I think the largest piece of legislation we're arguing about is whether or not public adjusting fees can be compensated for out of the carrier's pocket and not out of the policyholders, which I think is totally fair, right? I mean, if attorneys' fees are compensable, because why? Because you have to hire a professional, a representative, a fiduciary who's now going to work on a contingent basis to then go and represent you, spend his own money and his own time with the idea of making you whole later. How does he make you whole if he has to take a portion of what the claim value is, right? And because of that, I think I'm constantly explaining to potential clients all the time how they're saying, well, if the claim is $1 million and you take 30-40%, how do we ever get made whole? And I have to explain to them that we wouldn't be offering to take your claim on a contingent basis if we didn't think we could obtain our attorney's fees in addition thereto. And attorney's fees are compensable if and when the carrier fails to act under good faith and fair dealing. And under the facts of what we can see, that's what we have here. That's not the situation with public adjusters, whether it doesn't matter, it comes right out of their pocket. Whether it's at the outset of the claim or at the end of the claim, that's not fair to the insured, not fair to the public adjusters, not fair to the contractors. I mean, somebody is paying for that, and it's not the insurance carriers.
It's not the insured's fault that they have to now hire a public adjuster to compel an insurance carrier to do their job properly.
Right. And so I think that's a fairly easy sell to the legislation, but I mean, you're working against lobbyists for all the 4 major insurance companies. It is a David versus Goliath battle. So, but I will say, I mean, it's John Black. They give in Texas State Senate, they give him the floor when they invite Steve Badger to ask about the other end and what's happening from a 1,000-foot-up perspective. They give us the mic. They give us the opportunity to stand there and basically make our claims and have our complaints heard, because the insurance carriers would have it. Those lobbyists would, they wouldn't know that contractors are anything but, greedy, stealing, lying, cheating people that sling shingles out the back of their truck and buy extra bundles on the side. It just not. It doesn't. The representation is not there for contractors or policyholders, which doesn't make sense. But when you understand how much money insurance companies are pouring into not only lobbying but advertising, I mean, State Farm, Liberty Mutual, Nationwide, and Allstate, those 4 companies are in the top 10 of television spending and advertising every week.
To make policyholders feel like they're
your good neighbor.
Yeah.
Yes, you're in good hands.
Yep.
Right.
Yeah.
They're on your side.
Which is a tough battle sometimes for us as contractors, because we're just trying to get paid for all the work we do.
Right.
Simple. Like, we're not trying to rip off insurance companies. We're just trying to get paid for a service that we perform. And the policyholders sometimes get hung up in the fact that, or in the idea that they are in good hands or that they are being taken care of, and that makes it a little bit harder for us. How do you see contractors overcoming that with policyholders?
I would explain it like this. I mean, I deal mainly with large loss. We're dealing with 7-figure losses. If you have a 7-figure loss, that's equivalent. Let's just say you had a personal injury matter. There's 2 ways that in the civil realm you could be compensated: economic losses and personal losses. Physical injuries, economic injuries. Most attorneys operate in the personal injury realm, right? Plaintiff's attorneys, that is. They're arguing if you get hit by a tractor trailer, you're due $1 million, right? That's $1 million policy. That's why they're making commercials asking if you've gotten hit by a tractor trailer, because they carry $1 million policies.
Right.
Well, how many buildings carry $1 million policies? How many, buildings that carry $100 million policies incur $1 million worth of damage? Happens much more frequently than a tractor trailer hitting somebody in the back and disabling them. So, but if that's the situation, how many people that got hit in the back by a tractor trailer that are owed $1 million potentially that don't get an attorney, right?
Yeah.
Any?
None.
They need the representation. But in that scenario,
it's a different scenario though.
It is a different scenario.
You're getting a settlement, and all of a sudden it's a windfall settlement in a lot of ways for people, versus a property damage settlement that's direct physical loss.
Correct.
Like, you have to replace that.
Well, no. So in the personal injury realm, you're arguing for medical specials. You're arguing for the cost of repair, and then pain and suffering.
Pain and suffering, right?
Right. And so, interestingly enough, in personal injury realm, you have a lot of personal injury lawyers arguing for 3 times the medical specials. That's the way they, quantify how much they're owed. But why are they doing that? Because there's no law that says that a personal injury lawyer has to be paid in addition to what is compensated to the client.
Okay.
Right? There's no law that says attorney's fees shall be paid for a personal injury client against a third-party insurance company. But in the first-party realm, there are, and that's what people need to understand. And they don't, but that is probably the best piece of legislation out there for policyholders. And if you imagine how many policyholders have multi-million-dollar losses, it has to be that way, or else the 30 or 40% that attorney is taking out the claim, that's the contractor's profit.
Right.
That's exactly where it comes from. And so if it were up to the carriers, they would do nothing but whittle what they pay down to labor and material costs. They would have the homeowners out there paying the laborers and going to Lowe's and buying the materials their own, if that's how they could do.
Yep.
Matt's Guide, I mean, all those, it's just the whittling down of what they owe, such that our profit is at stake.
So
His
how
profit's
do
at
we
stake.
fix that?
Well, get the right representation.
Yeah.
Right.
Yeah.
I mean, start from the top.
I think a lot
Legislation, down to representation on the individual level and representation, on the macro level. But talk to your senators, talk to your attorney generals. Legislation is, I think that's a tough game. We have to fight the Supreme Court to protect, so like Barber Technologies or Ortiz just happened in Texas with regard to what they owe when they pay an appraisal award and whether or not they owe attorney's fees. That was a huge fight in the appellate courts, and we won. We won this past July, but we protect our profit. And so we have to do that in order to protect his profit. Because if I can't make my attorney's fees in addition thereto, then where do our fees come from? Correct.
Yep.
So we have to go from the top down. So we have to protect our ability to make our attorney's fees. I think extending legislation to enable public adjusters to make their contingent fees on top of the claim money as well would be great. And that enables them to protect his profit, because how many contractors take that 10% directly out of what they would ordinarily profit?
A lot.
Some.
A lot.
I don't know. I don't know any specifically, but not him. Not him at all. But that's that's what happens, and someone's got to pay for it. And if the insurance companies are delaying, denying, underpaying claims such that they have to enlist the help of a fiduciary to make them do the right thing and act reasonably, then they should pay for that.
You think there will be a time where insurance companies would just do the right thing? Or that legislation could fix that? Or is that something that's just always going to exist?
The trend doesn't seem to be going in that direction right now. I can tell you, my father was a contractor in the 90s. What I do today, he never heard of.
Never heard of it.
Never heard of it.
My dad's the same way. Like what we do now, we've never dealt with that.
That's right.
It's a different world, man.
It is.
It really is. And I think the insurance, companies, when, we have one right now that we're working on. It's it's going to be over $2 million. And it's here. It's in Colorado. And the insurance company decided to bring out 2 engineers in an 80-foot boom. I think I was telling you about this earlier. And then they said, we have already taken all of our documentation. We've got all of our photos. We've got emails from the adjuster saying, yes, there's hail damage on the property. He's already documented that there was hail. And they bring in a large loss adjuster, which is, it's normal. I mean, most adjusters don't have anything. They can't really write over $250,000.
That's
some
a
of them,
high authority.
Yeah, some of them.
$250,000's a high authority.
Some of them can't even write 100.
Yeah.
And then it goes from that to 250, and then above the 250, it's to a large loss claim adjuster.
Yeah.
And so the large loss claim adjuster comes in on this Monday, and me and the sales rep Steve met him out there, and he had 2 engineers with him. Well, they're there with an 80-foot boom, and they said they were gonna jump 4 buildings that day, and then 4 buildings the next day, and then they're dragging this thing out for a whole entire week. And just from my experience, I could jump all those buildings in 2 days with just ladders, just me. So I thought that was kind of weird that they were saying it was going to take a week to look at these 16 buildings.
His lawyer could do it. That's what I heard.
Yeah. So then they asked Steve. They called Steve and said, "Hey, we'd like you to come out and get up on the roof with us, and we want to, And he's like, "Was there a problem with what you see for hail?" And he's like, "No, there's no problem, but we want you to get up on the roof with us, and just to verify we're seeing the same thing you're seeing." And I called London, and I said, I think, we shouldn't be getting up on the roof with these guys. I mean, they're the engineers, they're the experts.
Right. What do they need your opinion?
What do they need our opinion for?
Didn't they go over you?
We already have, 500 photos of hail damage. I mean, it's obvious. We have 6 hail claims since 2016. In 4 years, that building's been hit 5 times. all 1 1/4 inch all the way up to 2 inch hail. So we know the building has had the same insurance for the last 20 years, 10 years. And so we didn't have to worry about that, because that is a possibility when you're dealing with these large claims where, if the storm hit and they didn't have the insurance and now they file a claim, well, they're not going to cover that because it was, before or after.
However, I've never seen a carrier point to a prior date of loss when they insured the building at that time, right?
Right?
Never
Exactly.
seen it.
Exactly.
Exactly.
Mm-hmm.
So they asked Steve to do that, and we respectfully declined because,
What was he potentially walking into in that situation?
I mean, a waste of time.
A waste of time?
I mean, the worst a carrier could accuse him of at that point is failing to agree to a mutual inspection. You'll see that in the reservation of rights letter. And that doesn't befund me, as old George Thorogood used to say. I don't really care about that. He's been out there 3 times. He's done the dog and pony show, which I don't even think he has to do that, but he does that to give some representation to the insured, some eyes and ears up on the roof, see what they're doing.
Opinion.
Right, and we also had already met with the original adjuster and verified damage. So there was no real reason for us to go back out there and get up on the roof and get into this, well, this isn't hell, and I'm an engineer, and you're an idiot roofer, and you know what I mean? I know what I'm doing, and you don't know what you're doing. So we just said, you know what, just write up your scope of work, and we'll go from there.
Yeah, and how many times has an engineer gone out onto a property and made a decision that was contrary to what the carrier was already deciding to do at that point?
They're not gonna bite the hand that feeds them too often.
Of course.
I ask that at every conference I go to if I get the opportunity to do a little Q&A,
Yeah.
and I've seen maybe 1 hand go up in over 2 years. It just it does, and that carrier probably was never hired again by the carriers.
London, let me ask you this question though. I mean, he's doing this thing as a contractor though. But how many? In what states is he going to be accused of UPPA though?
0.
I mean, but if you go to Texas and they decide that you've decided that the work that he's done as a professional contractor could potentially, they'll threaten it at least. They'll bring it up and say, "Oh, this is UPPA violation."
I simplify UPPA like this: draw a line in what you say, and whether you write it in an email or you're speaking to an adjuster, and put facts on one side and opinions on the other. And as long as you speak facts, you can't be in violation of UPPA. Impossible. The fact is, the damage is damaged right here. The fact is that in order to fix this damage, it's going to cost this much. The fact is, the policy says this, the law says this. Now, I mean, you go start quoting policy and law, they're guaranteed to accuse you of that, but they could never, convict you of that. Mind you, no one's ever been even charged with that I know of. Do you?
I don't.
I don't know
I've
of
seen
anybody.
plenty of letters. I've seen plenty of.
But I'll go on
threats.
record right now and say the first person that gets charged with UPPA, I'll represent them for free. I used to do criminal defense back in the day. I've done murder trials. I've done lots of stuff. You look at my record, I've won every single case that we've ever taken to trial, and I'll represent you for free. But my bet is nobody's ever going to even be charged. It's the boogeyman that they've got you running scared of. So, but just go out there and speak facts. Don't, once you cross into, this is what the damage is. This is how much it's going to cost.
In terms that they really don't understand. Because a lot of contractors have things that they say that I'm always like, man, I don't think that's really the way the policy works.
Then it's probably an opinion.
Right.
This says, the damage is this is how much it's going to cost, the policy says this, and therefore, in my opinion, you should cover it.
Right.
Well, you're not speaking on that. As long as you talk the facts, that the conclusions sort of, lead to themselves, right?
Right.
I can tell you that in that order, and I think I think what the contractors need to focus on is chronologically delving into the fact, or chronologically delivering the facts in the right way. Looking at a claim to make sure there's a covered peril. First thing, what's the date of loss? I mean, before he had a Hail Trace account, I gave him my Hail Trace login, and his guys were, sitting in the driveway and logging it in. That's fine. We pay for plenty of Hail Trace.
He's
Sorry, Derek. Sorry, Derek. We'll get you on that extra account. That subscription's on me. No, but figuring out the date of loss, and you can't pick it, but you can present them your Hail Trace report and say, so here's a hail map of your property. Tell me when you think the hail occurred.
Here's actual meteorologists
Well,
saying this.
that's a big issue with, especially here in Colorado, where we have, on our residential side of the company, Apex itself, right? We have a lot of insurance agents that refer us out. Well, they'll call, we'll let's say we don't know the data loss. Let's say we didn't track that one storm. Like I just found a storm that I'll tell you about later here. But I didn't know anything about this storm. I just found out about it yesterday. It's here in Colorado, right?
That's surprising.
And it's from 8/29 of this year.
Huh.
So small storm, little tiny neighborhood, but still, it's there, right? Well, I didn't know about it. I was told about it. We looked it up. It's there. Okay, it's on Hill Trace. Boom, right?
Sounds like a honey hole to me.
Sounds like it, right?
Right. So my thing is this: like when we call one of our, let's say it was an insurance agent lead, we call, we go out, we inspect. Yep, here's your photos. We send the photos to the agent, to the homeowner. Say, yep, it's it's a justifiable hail claim. You need to file a claim. They go out, we meet the adjuster. Well, the first thing the agent will say is, what's the date of loss, right? It's like, okay, when they ask you that question, they're trying to put you in a corner, right? And it's not really the contractor's job to do their job for them. I feel like, a lot of times with our agents, right? They're friends of ours. We know them, right? We give them the data loss, right? But if we're in another city or something like that, and they're saying, we want the data loss, we want photos, we need video. How do you know that this hail hit it? This and that and the other. Well, we use Hail Trace. Well, we don't verify. Oh, we use NOAA or whatever system. Core Logic, Weather Fusion. I mean, they're all different, but it's all storm tracking data. That they're using, whether it's NOAA or whether it's StormSight or it's Hail Trace or Core Logic Weather Fusion or whatever it is. So, that's their job to do that. I feel like when you get into that situation on a hail claim, they're saying, oh, when was it? I don't know, but here's my Hail Trace report. Here's 5 storms that's hit this property in the last 4 years.
And clearly
you tell
the property
me,
has damage. So
right. You tell me
damage.
which storm it is. It's not my job to do that for you. All I know is that's hail on the roof and it looks fresh to me.
Yeah.
It's dark black hail, bruising on the roof, on the shingles. So that's something that I would definitely tell contractors to be very, very careful about is, picking that storm date for them unless you 100% know it hit that date. Because these engineers might come in and say, oh, you said this storm date was 1.5 inch and, I've got a measure here that it was 1 inch. So this storm date happened last year and they weren't covered under this policy.
Yeah.
Yeah, there's some storm dates that we just know. I mean, it just very clearly, it was June 19th of 2018, or it was May 7th, May 8th of 2017.
Yeah.
But, when you're talking about honey holes, where you've got sporadic hail, I think that has to come from the policyholder.
Yeah.
You can't be the one picking that, because if you're wrong, one, potentially unauthorized practice of public adjusting, if that's even a real thing. Last I checked, it wasn't. But just spoke about. And then also the policyholder can come back on you and say, well, you mucked up my claim. You're the one that picked that date of loss. I didn't pick that date of loss. So I think having those tools and having those reports available, and even showing it to them on an iPad and saying, these are the reports that we have. This is what the damage looks like. Can you help me? Can you determine from this information when this occurred? And then have that submit that with an email. Because what I've seen is all too often they call it in and the carrier puts down whatever date. They're the one that's filling out the property loss notice.
Right.
They're the one that's committing that to a writing. And policyholders just calling it in, they can pick whatever date they want.
And normally that's just a team member in somebody's office, like a State Farm office. The homeowner will call and the insurance agent's on the golf course or he's doing training or he's not out of the office. It's just some team member that's sitting in the office that's answering the phone and she's taking down the information or he's taking down the information. And when was the date of loss? Well, I don't know. I mean, it was last week. Well, what day last week? I don't know. It was last year. Well, what day last year? And then they try to narrow it down to that specific date. And I understand that the reason why they're doing that is to either deny the claim up front or to say, yep, you know what? That was 2-inch hail for 15 minutes straight on that day. You know what? You had the policy. We're going to cover it. I understand their reasoning behind it, but it can definitely bite you in the butt pretty quick because just the one that I did right after that one over here in Denver, it was a major case unit for travelers, and she came out and she said, they filed this from 5/29 of 2020. I'm like, I've been out here since June 5th of last year. She's like, well, the policy was still in place, but last year they had a 2%. This year they have a 5%. I'm like, well, it was from July 5th of 2019. I said, I can show you documentation going all the way back from emails, my pictures, my original pictures that I took when I was up on the roof. These are all in company cam.
That's cool.
She said, you know what, don't worry about it. We're going to file it under the July 5th because she knew. But, you know, even hitting a 5% deductible on that was a zero payout for the client. See what I mean? So she could have wrote up, you know, $1 million and they're still getting $0. So that was very important that, you know, you make sure that if it is that day, you better make sure it's that date and, you know, stick to that.
And we just had a claim, a client just recently retained me. He filed a claim in June of this year for a storm in October of last year. So June of this year, 2020, he filed a claim for October 20th, 2019, and they put down October 20th, 2020. The carrier took 45 days to issue a reservation of rights letter explaining that the claim that you made was actually at a time that does not even exist yet, and they wrote that letter in August. So if you have a clear indication, so I think, you know, whoever is answering that phone, I think they're, by design, I think the questions that they ask about the storm date are designed to get the claim off the track. Or to get a date that might not be right, because what does that do? It buys the carrier time.
Yeah.
If even if and the ultimate detriment is it gives the carrier an out because they don't cover. There's a possibility they could say the damage occurred on this date, and oh, lo and behold, they don't cover it on said date. So if you give them that opportunity, I would not give them an inch. So what the contractor can do is present this to the policyholder, tell them the importance of getting this right, and then asking that they submit an email to the agent with that date of loss. And I've given him you've got that letter that you got.
Yeah, what I do is I tell you, if I don't know, and I'm serious, like if I really don't know, I just say date of discovery. And they say, well, what does that mean? I was like, well, I was on the roof today, so I don't know when it hit. Well, what do you mean you don't know when it hit? I'm not a meteorologist. Yeah. You guys are the insurance carrier. You guys have storm tracking.
We're just telling you there's a claim here.
I'm just telling you there's hell on this roof and it looks fresh, and here's my photos. Date of discovery. What's the date? Today. Just file it for today. I don't know when it hit. Yep. And they get mad because they don't like that. You know, they want that data loss on there, and they want to lock you into that was 1 inch hell on that day, and was the policy in place at that time. Right. So you got to be careful with that stuff.
Yeah, and if you ever have a question about it, I think figuring out ahead of time and calling an attorney or calling an adjuster, figuring out the coverages with the client, presenting them hail reports, whether it be one or multiple, and saying, what do you think it is, and kind of getting to that conclusion, so that even if you're incorrect at that point, at least you're not liable for being correct, and you got that date from the policyholder, and that's what you're calling in, versus potential issues that could happen, if you get it wrong. So that's a good one.
That's awesome.
That's a good one.
You guys have built this great relationship. I think it's been super beneficial for both of you to do this. I think contractors need to have that type of relationship like you guys have with their attorneys. It's probably been extremely good for you. It's been good for you, and it's something that you guys both learn from each other and become better at your craft. So I appreciate you guys spending time with us today to talk about this stuff and to open up a little bit like this, because this is definitely a lot of really awesome information. So thank you both.
Yeah, it's been great. Thank you.
Cool.
Thanks so much for watching today's show. Make sure to like and subscribe our pages so that you can stay up to date with every episode. And by the way, this show is all about you, the American Contractor. Be sure to comment and let us know what you want to hear about and what subjects you want us to touch on. We'll be sure to include them in a future episode. Thanks again, and I hope you have a great day.